It comes with quite a bit of tension on the court. For example, even justices who agree with part of this, like the concurrence, have fractures. Chief Justice John Roberts, also a Bush appointee and also seen as a critic of abortion, did not formally dissent. He upheld this Mississippi law, but he also wrote separately to assert that he doesn't really agree with what this bare 5-vote majority did. Basically, if it weren't for the Trump appointees, Roberts would have stopped this. He says he would have preferred not to overrule Roe entirely and instead operate on, quote, narrower grounds. Of course, this majority does end Roe entirely, and that means it's open season for states to ban abortion in all sorts of ways. The nation's high court ruling also that judges across the country must uphold virtually all abortion regulations. I mentioned this briefly in the top of the program, but I want to show you what this means. Justice Alito writes that, quote, rational basis review will be the appropriate standard for challenges because, again, as he put it, abortion is, quote, not a fundamental constitutional right. So a law regulating abortion is entitled to, quote, a strong presumption of validity. In other words, when these states go forward, not only with the automatic trigger laws and other types of laws that we've described today, but when they go forward with even other far more extreme measures, perhaps trying to ban Plan B and types of contraception, under today's precedent, those types of laws or rules have to be treated as if they're automatically valid. Then the dissenting justices, of course, have their views of all of this. They point out that this could impact taking medication in one's home. They note that some states may compel women to carry to term a fetus with severe physical anomalies, sure to die within a few years of birth, and that without any exceptions for when the woman is the victim of rape or incest, a woman will have to bear her rapist's child, or a young girl, her father's. Let's pause right there. This is difficult stuff to talk about and to consider, but all the more difficult for people to face or live through. This is what one of our guests just earlier tonight referred to as law of forced pregnancy, of forced childbirth. Now, the court could have provided any such exceptions in the majority opinion. As written, it really does not seem to. So this is, as the dissent put it, a type of opinion that would uphold, based on what we can tell, states that want to force people to carry their rapist baby to term. That's part of what's in here. Now, Justice Alito asserts that all of this today, this new ruling and this change to law, is required by history, that it has nothing to do with a pro-life stance. Indeed, Alito insists on behalf of the court majority that they are neutral on the issue of abortion. Quote, our opinion is not based on any view about if and when prenatal life has rights. Now, this matters. Again, I mentioned if we're going to be a democracy and we're going to deal in facts and self-governance, think about what this court wants everyone to believe today as they exercise power over people's lives and bodies. They are claiming with a straight face in writing it's all a neutral exercise in history that just happens to overlap with what sounds like a personal religious agenda about life or prenatal life, as well as the multi-decade right-wing effort to get these very people on the court. It is hard to believe, in the most diplomatic, nicest way possible, to say it. It's hard to believe that that's true. And by the way, it's certainly not what Justice Alito's fans believe. They think President Bush put him on the court for the same reason Trump put his 3 judges on, that they would be what they were today. Ironclad pro-life votes, that they were just saying what they had to say when they talked about precedent at those confirmation hearings. And look no further than Alito's own writing today in this opinion to see some of the tells about why abortion is just different. This is not legal history. This is not external science. This is Justice Alito admitting why he did what he did. Because to distinguish against other also popular rights, he promises this case will be different, meaning the court will not necessarily take out other rights because abortions, quote, destroy potential life. Well, right there, when you just read what they say, that's not neutral. That's a view of life and when it begins and what its value is. The three dissenting justices point out that the court does not, quote, act neutrally when it leaves everything up to the states. It's taking sides against women who wish to exercise the right. And, on the other hand, taking sides, quote, for states that want to bar them from doing so. Now, Alito reasons that Roe is not constitutionally protected provision and that other rights would somehow be different, rights that have been accrued over the years.
A historic decision about abortion. In the first 3 months of pregnancy, only the woman and her physician may decide whether she may have an abortion.
Supreme Court's historic ruling on Monday upholding the legality of abortion but allowing states to impose restrictions.
The court ruled in favor of two Texas men who challenged a state law that made homosexual conduct a crime.
It was another historic day at the Supreme Court. Marriage equality is now the law of the land.
And that's true today. Marriage equality is the law of the land, and right now states cannot imprison people for who they have sex with because they have sex with someone of the same gender or however that's defined. You cannot be imprisoned for that in America, but that's only because of the case you just heard those newscasters refer to, that Texas case. But now those rights are also in danger here. They're at risk. And Alito says it's unfounded to fear that anything could happen to those rights. Quote, unfounded. That somehow is a leap. He says the line is now at abortion. But the justices will decide cases as they come before the court. And when you start removing fundamental rights or a right to privacy or a right to certain personal, intimate decisions, well, this is how the law works. This is how they teach it in law school. You take out a bunch of the foundations, the other stuff can fall. The dissenting justices deal with this as well today. And again, we think you should have a firm understanding of the details and the clash, because they note that the lone rationale for what the majority does, saying abortion's not, quote, deeply rooted in history, the same could be said of most of the rights the majority claims it's not tampering with. So contrary to what Alito says, it actually seems perhaps the fear is founded. One justice already made it known that is what he wants to do. Justice Clarence Thomas used today's decision, and you think about how impactful this is, how worried people are, how affected people are, and he just went completely off the books to talk about what else he thinks should be overruled, saying we should reconsider the court having rights to those rulings you just heard in those newscasts, contraception, same-sex marriage, and even same-sex intercourse. You have a Supreme Court justice today in this opinion about Roe going out of his way to bring up something nobody asked for, but apparently what he wants to do, and he's telling the world, he wants to be able to allow states to imprison people for the sex they have. So legally, we're going back 50 years today. Some of what they're talking about goes back 100, 150 years. Here's another quote. Until the mid-20th century, there was no support in American law for a constitutional right to contraceptives. The dissent is pointing this out. Again, this is why Alito's logic is so concerning to so many. And the court's dissenters, that's Sotomayor, Kagan, and Breyer, say, quote, either the majority, Alito and co., either they don't really believe their own reasoning, or all rights that have no history stretching back to the mid-19th century are now insecure, are now in danger. This is what the court is doing with its powers. And everything we just went through has to do with rights, with how the Supreme Court, which is the final word in our system, not the first or the second, but the final, how they deal with rights. Then you have the sexism in how these laws are written and who's on the court upholding them. The dissenting justices come at this quite clearly. They note that when we talk about the, quote, people who ratified the 14th Amendment, which the justices do, well, they weren't just people thinking about those rights. They were all men. They explained the male ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation. That is how Supreme Court justices sound when they sound sarcastic. Obviously, issues are as serious as a heart attack, as serious as people's lives. And the point they're making is, if you buy this Justice Alito claim that everything has to be decided basically by the standards of this period of history, if you buy that, then you're only going to be taking the antiquated views of the men who were in charge then at a time when women did not have full legal and political rights. You might think it'd be controversial to admit out loud that that's your endpoint. It'd be like describing civil and voting rights laws during the time of slavery and saying, let's look only to the slaveholder's mindset. It is the gender version of that, and it is in an opinion today. Now, women do not get pregnant on their own. This opinion forces women nationwide to carry what will be, according to their personal choice, for some of them, an unwanted situation to term. And there's no provision for any extra responsibility or legal obligation for the men who are part of that, who are doing the impregnating. Which brings us to someone who was replaced when she passed by Donald Trump's appointment process, the late Justice Ginsburg, discussing that women with means who may travel in this type of ruling would still have some options, some still burdened by the state, still burdened by the government, still burdened by male legislators, but they would have some options to hopefully for them find legal and safe abortions, which means in a very real sense, these types of laws do what is not supposed to be done. They discriminate on the basis of both gender and class, with poor women the most impacted.
Take the worst case. Suppose Roe v. Wade is overruled. Who will be affected? The only women who are genuinely affected by restrictive abortion laws are poor women, voiceless women, and that's a very sorry situation.